What you know, alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Saturday, December 20th. I actually recorded this yesterday, but didn't have time to edit and get it out before I had to go to my son's fire department's Christmas party. And I have to brag for a moment here. He won Firefighter of the Year. He was shocked. He had no clue. And I have to say, one of the proudest mom moments I've had with that kid so far. He has worked so hard getting his Firefighter 1 and 2 over his sophomore and junior years of high school, and then getting his EMT his senior year. Not too shabby to be 18 years old. So this next episode, we really get into the part of the filing that talks about the justification the district court had in disqualifying Mark Means. It's a bit lengthy, but there are some nuggets in there. And a big topic of discussion is how Lori was incompetent during a lot of this when the decision was being made to disqualify Means, and also some unethical things that Means did in the process. So let's jump in. We are going to jump into the argument of the state's response to Lori's appeal. Let's jump in. Vallow has failed to show that the district court violated her Sixth Amendment right to counsel of her choice by disqualifying her attorney. And Part A is the introduction. The district court properly acted to protect Vallow's Sixth Amendment right to the effective assistance of counsel by disqualifying her attorney, who had previously represented her co-conspirator with respect to the same conspiracy. Vallow's right to her counsel of choice does not extend to an attorney who is laboring under an actual conflict or serious potential conflict of interest. Nor could Vallow's proffered waiver of the conflict suffice because she was incompetent and could not knowingly, intelligently, and voluntarily waive her right to conflict-free counsel. And because the nature and circumstances of this case required the district court to reject any waiver to protect the fundamental fairness of the proceedings, the district court did not err. Part B, the standard of review. The decision to grant or deny a motion to disqualify counsel is within the discretion of the trial court, and they list several cases. Deciding motions to disqualify, even if those matters are grounded in the ethical rules, is a proper discretionary decision to be made by the trial courts of this state. When a violation of a constitutional right is asserted, Idaho's appellate courts will defer to the trial court's factual findings unless those findings are clearly erroneous. C. The district court acted well within its discretion in disqualifying Means from representing Vallow. The Sixth Amendment protects a criminal defendant's rights to the assistance of counsel for her defense. One element of the right to counsel is the right of a defendant who does not require appointed counsel to choose who will represent them. And they list a couple of cases here. But the right to choose one's own counsel is circumscribed in several important respects, and they cite Wheat versus the United States. As relevant here, a criminal defendant does not have an absolute right to the counsel of his choice when that counsel is burdened by a conflict of interest or the serious potential for a conflict of interest. A defendant can sometimes waive the conflict, though a waiver by the defendant does not necessarily solve the problem because the district court has an independent interest in ensuring that justice is done. A district court has broad discretion in refusing a proffered waiver of an actual conflict or the serious potential for a conflict. The district court acted within its broad discretion when it disqualified Means from representing Vallow. Specifically, the district court properly, 1, found the existence of an actual conflict or serious potential for a conflict. 2, recognized Vallow could not waive any conflict because she was incompetent at the time of the disqualification decision, and 3, rejected any proffered waiver because of the seriousness of the charges and risk of prejudice to Vallow. Number 1, the district court properly found an actual conflict or serious potential for conflict because Means represented both Vallow and Daybell during the alleged conspiracy. The district court properly found a conflict of interest or serious potential for a conflict arose from Means representing both Daybell and Vallow in the context of the same criminal conspiracy. A district court can disqualify defendant's counsel of choice not only by a demonstration of an actual conflict, but by a showing of a serious potential for conflict. They cite Wheat versus the U.S. Unfortunately for all concerned, however, a district court must pass on the issue, not with the wisdom of hindsight after the trial has taken place, but in the murkier pretrial context when relationships between parties are seen through a glass darkly. Thus, district courts should be given substantial latitude in this area because the likelihood and dimensions of nascent conflicts of interest are notoriously hard to predict, even for those thoroughly familiar with criminal trials. When it comes to conflicts, multiple representation is king. They cite Collier versus Sullivan. A possible conflict inheres in almost every instance of multiple representation. In previous cases, we have recognized that multiple representation of criminal defendants engenders special dangers of which a court must be aware. Indeed, courts routinely find conflicts where the same attorney represents co-conspirators in the context of the same conspiracy, regardless of whether the representation is successive or concurrent. They cite U.S. versus Martinez. It is true that, having previously represented a co-conspirator with regard to the same matter, defense counsel should not have represented defendant. They cite U.S. versus Ruiz, finding serious potential for conflict in successive representation of co-conspirators. They cite another case, finding serious potential for conflict where attorney represented a co-conspirator during part of the pre-indictment phase of this case. And then U.S. versus Collins, finding serious potential for conflict and disqualifying counsel who previously represented co-conspirator, even though prior representation was very limited in scope. The potential concerns evoked are legion. The conflicted attorney may pull punches on cross-examination of his previous client, or his knowledge regarding his previous client could provide an advantage on cross-examination. The conflict could compromise counsel's ability to explore plea negotiations should the current client choose to, and it can risk the attorney improperly utilizing confidential information gained from the former client. They cite United States versus Culp. Because of the lawyer's continuing duty of confidentiality, the representation, be it simultaneous or successive, of more than one defendant charged in the same criminal conspiracy, inevitably it presents a conundrum for the lawyer who is so engaged. The risk of a conflict significantly increases when the disqualification decision is made early in the case, since the defense does not yet know much of the substance of the government's case in chief, which necessarily creates uncertainties in defense strategy. They cite U.S. versus Cleveland and also Wheat. A few bits of unforeseen testimony or a single previously unknown or unnoticed document may significantly shift the relationship between multiple defendants. And even if it turns out that neither co-conspirator chooses to turn on the other, they might still have divergent interest at sentencing when issues such as the defendant's role in the offense and his relationship to other defendants come into play. They cite a couple of cases, and it says recognizing defense attorneys in multiple defendant cases often minimize the culpability of their own client by emphasizing that of another defendant. With these concerns in mind, the presence of a conflict or serious potential for a conflict is self-evident in this matter. For starters, there can be no doubt but that Means represented Daybell with respect to the alleged conspiracy. Means publicly stated as much on social media when he posted on April 28, 2020, "Please note that this office represents Mr. Chad Daybell. If any agency, investigative authority, etc. wishes to contact my client, please contact my office directly." Neither the content nor the source of the communication has been disputed. Means also contacted the prosecutor overseeing the state's efforts and asked him to direct investigation efforts relating to Daybell or Vallow to him. He also published a press release indicating he represented Daybell, and Means expressly informed the court that he represented both Vallow and Daybell. Means was not the only person involved in the representation to indicate the representation occurred. At the same time, Means was publicly stating he represented Daybell. Daybell indicated on a phone call with Vallow that Means was both Daybell's and Vallow's attorney. In light of this evidence, the district court properly found that Means concurrently represented the co-defendants in those cases within the time frame of the alleged conspiracy. By the way, it just hit me when Mark Means said in court that he did not represent Chad, and Rob Wood's face, he just kind of like made this funny expression and cocked his head like, what? I need to find that and post that for you guys, maybe on the next episode. Just popped in my head. Moving on, the factual finding supported by the record leads to the inescapable conclusion that a conflict or serious potential for conflict existed. Under the Idaho Rules of Professional Conduct, Means had a conflict that, at the very least, had to be waived by Vallow and Daybell because of the significant risk that his representation of Vallow would be limited by his prior representation of Daybell. As the district court explained, in the context of this case, because Daybell and Vallow are named co-conspirators, necessarily, they have interests adverse to one another. The district court's conclusion is supported by the same rationales articulated by other courts who have found a conflict in similar situations. For example, if Daybell decided to testify, a decision over which Means had no control, Means may either pull punches on cross-examination or benefit from the knowledge he obtained from his former representation of Daybell. Means' divided loyalties may also interfere with any plea negotiations, and there is always a risk that Means would utilize, intentionally or inadvertently, information protected by his previous representation of Daybell. Moreover, as the district court explained, this case was in its infancy at the time it disqualified Means. Vallow had not yet been arraigned. Neither Means, Vallow, who was at the time incompetent, Daybell, nor Pryor could accurately predict at the time how the defense strategy would play out for either the trial or the sentencing. This significantly increased the risk that a conflict would occur given the likelihood that Vallow or Daybell could turn on the other, either to attempt to avoid a guilty verdict or the death penalty. Vallow argues the district court erred because the record does not contain concrete evidence of an actual conflict, such as specific information Means learned when he represented Daybell that would affect his representation of Vallow. Her demand for concrete answers in the murkier pretrial context would place an impossible burden on district courts and runs contrary to the U.S. Supreme Court's decision in Wheat. The very nature of trying to predict how potential conflicts will play out necessarily includes some amount of speculation. Indeed, the primary reason the court affirmed the disqualification of defense counsel in Wheat was that the government intended to call defense counsel's former client as a witness and might readily have tied certain deliveries of marijuana by the former client to the defendant. Neither of those eventualities could have been known by the district court when viewing the situation as it did before trial. Yet the Supreme Court affirmed the district court's instinct and judgment based on experience in making its decision, even though other district courts might have reached differing or opposite conclusions with equal justification. And it says, see also U.S. versus Sotelo, rejecting argument that district court's disqualification decision was unsupported and dubious speculation as to a conflict because the evaluation of the facts and circumstances of each case must be left primarily to the informed judgment of the trial court. They cite U.S. versus Sanders. Thus, although conflicted counsel may think he learned nothing that would be useful in cross-examining his prior client, it may be next to impossible to predict with certainty that such is the case. Here, the district court had a capital case that was in its infancy, making the likelihood and dimensions of nascent conflicts of interest notoriously hard to predict. But the court had in front of it sufficient facts to reasonably conclude an actual conflict or serious potential for a conflict existed. Means had concurrently represented two co-conspirators on the issue of and during the time frame of the alleged conspiracy to commit multiple murders. He continued to represent one of the co-conspirators and planned to do so through trial. The co-conspirator, who was his former client, had alluded he had shared confidential information with Mr. Means that the former client and co-conspirator believed would be covered by attorney-client privilege, and both co-conspirators were scheduled for a joint trial, which would invite all the conflict issues explained above. The district court acted well within the substantial latitude the U.S. Supreme Court has given it when it decided an actual conflict or a serious potential conflict existed that would require, at the very least, a waiver of the conflict from Vallow. Number 2, Vallow could not waive the conflict because she was incompetent. The district court's finding of a conflict or serious potential of a conflict was sufficient in this case to disqualify Means without deciding whether the conflict could be waived because Vallow was in no position to waive the conflict. To be valid, a waiver of the right to counsel must have been effected knowingly, voluntarily, and intelligently. They cite State versus Lovelace. Just as with the relinquishment of other important constitutional rights, waivers of conflict-free counsel must be knowing, intelligent acts done with sufficient awareness of the relevant circumstances and likely consequences, and courts must accordingly indulge every reasonable presumption against the waiver of the unimpaired assistance of counsel. They cite Douglas versus U.S. There is no controversy here. There appears to be unanimous Federal Circuit Court consensus that a criminal defendant's waiver of the Sixth Amendment right to conflict-free counsel must be knowing, voluntary, and intelligent. They cite State versus Duffy. And that standard requires something more than mere competency. They cite Godinez versus Moran. A criminal defendant may not waive his right to counsel unless he does so competently and intelligently. U.S. versus Stites, explaining even a competent person may not have the mental ability to waive a constitutional right. At the time, the district court disqualified Means as Vallow's attorney. Vallow was not competent to stand trial according to Idaho law. If Vallow lacked the capacity to understand the proceedings against her or to assist in her own defense, she could not possibly waive a fundamental constitutional right knowingly, voluntarily, and intelligently. Vallow argues any conflict was mitigated because she previously signed a waiver prior to being declared incompetent. But the waiver erroneously espoused Means' flawed and doubly rejected theory that he had provided only limited representation to Daybell. A waiver that misstates the nature of the conflict is no waiver at all. They cite a case. The waiver document stated that there was no conflict of interest, so it can hardly be read as waiving one. Given the erroneous description of the conflict in the waiver itself, Vallow's signing of the waiver does not constitute a knowing, intelligent, and voluntary waiver of the actual conflict at issue. Moreover, a conflict waiver signed prior to the issuance of an indictment is not valid. They cite a case that says the document was signed before the indictment was issued and a few years before trial, so it could not have taken into account the actual scope of the case as it proceeded. Vallow signed the waiver she cites on March 31, 2020, more than 1 year prior to the grand jury's indictment. At the time she signed the waiver, she had no knowledge that she would be charged with murder in a death-eligible case. Factors any reasonable person would consider in deciding whether to waive a fundamental constitutional right. Thus, Vallow had not signed a legally valid waiver at the time of the district court's decision, and her incompetence to proceed to trial meant she could not sign one. Vallow also suggests the district court should have waited until Vallow's competency was restored to decide the disqualification issue so she could decide whether to sign a waiver. However, as the district court explained, it could not wait to decide the disqualification issue and properly protect Vallow's constitutional rights because Means continued to actively represent Vallow under a conflict of interest while she was incompetent, including by engaging in suspect ethical behavior. By publicly filing apparently privileged information Means obtained from Vallow under the umbrella of the privilege she enjoys. Though, to be clear, the district court left the door open to Vallow, raising the issue again once competent, and they, quote, "If and when Vallow is restored to competency, the court could conduct an inquiry into her interest in waiving qualified counsel. However, until such time, this court's duty to protect her rights remains." Neither Vallow nor her counsel took the district court up on its offer. Because the district court properly found a conflict or serious potential conflict existed and Vallow could not waive the conflict, The district court properly disqualified Means as Vallow's attorney. The next section. The district court properly found the conflict could not be waived. Even if the district court could have accepted Vallow's March 31st, 2020 waiver as knowing, intelligent, and voluntary, the district court properly decided the conflict in this case could not be waived. The district court must be allowed substantial latitude in refusing waivers of conflicts of interest, not only to those in rare cases where an actual conflict may be demonstrated before trial, but in the more common cases where a potential for conflict exists, which may or may not burgeon into actual conflict as the trial progresses. They cite Wheat. A waiver is not always a sufficient cure when a conflict or serious potential conflict exists because courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. Two primary goals in deciding whether to accept the waiver of conflict-free representation are to protect the critically important candor that must exist between client and attorney, and to engender respect for the court in general. They cite U.S. versus Moscone. To that end, the trial court may enforce the ethical rules governing the legal profession with respect both to client-attorney communications and to conflict-free representation. Again, regardless of any purported waiver. Even in the murkier pretrial context, courts have readily identified the representation of multiple co-conspirators as a serious potential conflict that may justify refusing a waiver. They cite U.S. versus Sotelo, affirming district courts' refusal to accept waivers from co-conspirators represented by same counsel because district court believed a conflict would arise, particularly in pretrial plea negotiations. In the case of successive representation, the probability of prejudice dramatically increases in circumstances where the attorney represented a co-defendant during the pre-indictment phase of the same proceeding. They also cite Moss versus the U.S. This probability reaches near certainty where the attorney's former and current clients collaborate to mount a defense. The potential for harm is further increased where the representation of the defendant was paid for by a co-defendant. See Wood versus Georgia, which says ultimately the evaluation of the facts and circumstances of each case under this standard must be left primarily to the informed judgment of the trial court. The district court acted within its substantial latitude when it found the conflict or serious potential conflict could not be waived. In addition to the issues explained above, the district court had at least 3 additional reasons to reject any waiver. First, the nature of the case weighed in favor of not accepting a waiver. It says see Wheat versus U.S., affirming decision to reject waiver in part because the attorney sought to represent multiple co-conspirators in a complex drug distribution scheme. The state charged both Vallow and Daybell with a massive conspiracy resulting in the deaths of 3 people, and this was a family affair. The state's theory was that Vallow and Daybell engaged in their criminal conduct and killed their own family members, 2 of Vallow's children and Daybell's wife, so that Vallow and Daybell could be together. Even the complex drug distribution scheme in Wheat could not hold a candle to the complicated conspiracy with which Vallow had been charged. And Vallow's alleged co-conspirator had facilitated and paid for Means representation to boot. See Wood versus U.S. Courts and commentators have recognized the inherent dangers that arrive when a criminal defendant is represented by a lawyer hired and paid by a third party, particularly when the third party is the operator of the alleged criminal enterprise. Second, as the district court explained, its decision considered Means' unusual behavior in the case. Means potentially made himself a witness in the case, thereby increasing the risk of conflicts by filing multiple pleadings in the form of declarations containing factual assertions of Mr. Means submitted under penalty of perjury. Yet the Idaho rules of professional conduct stress that an attorney should avoid becoming a witness in his client's case. The district court was also concerned by what appeared to be Means' intentional or unintentional waiver of Vallow's attorney-client privilege, where Mr. Means had submitted to the court purported facts from statements Vallow made to Mr. Means under the umbrella of the privilege she enjoys, while she has been deemed incompetent to proceed. A second apparent violation of Idaho's ethical rules for attorneys. The district court's reliance on this behavior to refuse to accept any waiver was proper. See Moscone. The trial court may enforce the ethical rules governing the legal profession with respect both to client-attorney communications and to conflict-free representation. Again, regardless of any purported waiver. They cite U.S. v. Stites. A defendant cannot complain because a well-informed trial court would not let a lawyer who had already grossly misbehaved in the case return to the scene of his misbehavior. Vallow downplays the district court's concerns by labeling Means' ethically suspect behaviors as idiosyncrasies and claiming Vallow had the right to choose those idiosyncrasies. But given Vallow was incompetent at the time, nothing in the record suggests Vallow was aware of or chose Means' behavior that had raised serious concerns with the district court set to preside over her capital trial. Even if she wanted to choose Means' ethically suspect behaviors, Vallow did not have the right of her counsel of choice if that counsel could not follow the ethical rules. The district court had an independent interest in ensuring that Vallow's case was conducted within the ethical standards of the profession, and that her high-profile legal proceedings appeared fair to all who observed them. Third, the district court was confronted with two facts that made this virtually impossible task even more difficult. Vallow was incompetent and faced the death penalty, and it says to see Wheat. Stressing the difficulty of the analysis meant these decisions must be left primarily to the informed judgment of the trial court. The district court was primarily concerned with protecting Vallow's fundamental right to the effective assistance of counsel, exactly as it should have been. It says to see Wheat. The essential aim of the Sixth Amendment is to guarantee an effective advocate for each criminal defendant, rather than to ensure that a defendant will be represented by the lawyer whom he prefers. And because Vallow was incompetent at the time, all the district court had was Means' instance that Vallow would want to waive any conflict so that he could represent her, even though Vallow was now charged with capital offenses and the stakes were infinitely higher than they had been before Vallow was determined to be incompetent. And they cite Wheat. Nor is it amiss to observe that the willingness of an attorney to obtain such waivers from his clients may bear an inverse relation to the care with which he conveys all the necessary information to them. The district court was, in effect, hamstrung by Vallow's present inability to be thoroughly examined to ascertain whether she could knowingly, intelligently, and meaningfully waive her right to conflict-free counsel. In those circumstances, the district court decided to cautiously act in favor of Vallow's right to the effective assistance of counsel by disqualifying Means and appointing a death penalty qualified attorney as lead counsel. The court should affirm that decision. The next section, Vallow has failed to show the district court committed fundamental error by violating her Sixth Amendment right to the assistance of counsel. Introduction. Vallow's framing of this issue is both fatal and flawed. Set on placing blame on the district court for not hearing her attorney's objection to his own disqualification, she tries to turn the district court's denial of her motion to intervene in a separate criminal case into a constitutional violation. But in reaching beyond her grasp, she fails to recognize that the only reason her attorney's objection was not heard is that he failed to communicate the way lawyers do, by filing an objection in their client's case. The district court did not err, much less fundamentally err, by refusing to allow Vallow to intervene in a separate criminal proceeding. The next section, standard of review. Alleged constitutional errors during trial that are not followed by a contemporaneous objection must be reviewed under the fundamental error doctrine. The next section, the district court did not commit fundamental error by denying Vallow's attorney's request to intervene in a separate criminal case. The district court's denial of Means' motion to intervene in the Daybell case did not constitute fundamental error. To prove fundamental error, Vallow must show that any error in the district court's denial of means motion to intervene, number 1, violated an unwaived constitutional right, 2, plainly exists, and 3, was not harmless. She cannot do so. The next section, the district court's denial of means motion to intervene did not violate an unwaived constitutional right. Vallow has failed to show the district court violated her right to counsel by denying her counsel's request to intervene in a separate criminal proceeding. The Sixth Amendment guarantees a criminal defendant the right to counsel during all critical stages of the adversarial proceedings against him. They cite Estrada versus State, quoting U.S. versus Wade. In determining whether a particular stage is critical, it is necessary to analyze whether potential substantial prejudice to defendants' rights inheres in the particular confrontation and the ability of counsel to help avoid that prejudice. Vallow's claim that the district court deprived her of counsel by refusing to allow means to argue at a hearing in the Daybell case fails for multiple reasons, starting with the doctrine of invited error. The doctrine of invited error applies to stop a party from asserting an error when the party's own conduct induces the commission of the error. They cite Beebe versus North Idaho Day Surgery. Put simply, errors consented to, acquiesced in, or invited are not reversible. Vallow's entire Sixth Amendment claim rests on the district court's refusal to grant means motion to intervene, which she interprets on appeal as the district court affirmatively stopping her counsel from being heard. But that is not what happened. The district court ensured both Means and Archibald were present at the hearing. Then, when it denied Means' motion to intervene, it expressly stated that it misunderstood Means' request to be for Vallow to become a party in Daybell's case, and they quote, "It's not a request to allow argument on an issue affecting your client, Mr. Means," end quote. Despite the district court's clear explanation of its ruling, Means remained at the rest of the hearing but never asked to be heard. The district court ensured Means was present at the hearing. It did not also have an obligation to open Means' mouth. In a footnote, it says the district court did make clear at the end of the hearing that it did not allow for Means' testimony, but noted he was not called as a witness anyway. This changes nothing. Vallow's argument on appeal is not that the district court should have allowed her attorney to testify as a witness at the hearing. Means also failed to file his objection in the proper form, which was his client's case. Means' failure to seek an opportunity to be heard either by filing his objection in his client's case or speaking up at a hearing at which he was present was, at the very least, acquiescence in the error Vallow now erroneously claims on appeal. Even setting aside invited error, the procedural history of Vallow's case confirms she was not denied the right to counsel with respect to the state's motion to disqualify Means. The state filed its motion to disqualify Means in Vallow's case on July 27, 2021. The district court entered its order in Vallow's case disqualifying Means on December 28, 2021. In the 5 months between the state filing its motion and the district court granting the motion, Means did not file a substantive response or otherwise object in Vallow's case to the state's motion. This, even though Means filed at least 9 other filings in the same period, substantive motions and responses, such as a motion to dismiss the indictment and an objection to proceedings occurring in Daybell's case. For whatever reason, Means chose not to file a response or otherwise object to the state's motion in the appropriate forum. That is not the deprivation of counsel. Without acknowledging Means' failure to file anything in the proper forum, like his client's case regarding the state's motion, Vallow now argues the district court somehow violated her Sixth Amendment right by refusing to allow her counsel to argue a motion in a different criminal case. She cites no authority for the proposition that a criminal defendant has a Sixth Amendment right to have counsel argue in a co-conspirator's separate criminal case. And in all the examples she gives of courts identifying critical stages, the courts were obviously referring to stages in the defendant's own criminal proceedings, giving as examples post-indictment police lineups, arraignments, preliminary hearings, and sentencing. Vallow has the right to counsel in the criminal proceedings against her. She does not have the right to counsel in the criminal proceedings against someone else. And they cite Estrada. The Sixth Amendment guarantees a criminal defendant the right to counsel during all critical stages of the adversarial proceedings against him. Even though Vallow did not have a constitutional right to have counsel heard at the Daybell hearings, the district court was careful to include both Means and Archibald in the hearings in the Daybell case. The district court did not allow Means to formally intervene, but it allowed both Means and Archibald to be present for the sealed hearing in the Daybell case because it recognized the motion to disqualify really does pertain to both cases as it's been filed in both cases, and it's appropriate for determinations to be made in each of the cases, as well as having all counsel appear as they are here today. The state also explained that it did intend for this motion to be filed in both cases because it's an applicable motion to both cases. The state even went so far as to explain, with Means present, that the Vallow case was the more appropriate place for Mr. Means to raise his argument. Means heard all of this and still chose not to file a response to the state's motion in the Vallow case, despite affirmatively arguing we have two different cases. Vallow concedes the hearings were heard under a different case number, but argues the case number does not matter because the topic of the hearing was whether to disqualify her counsel. But the parties and the district court were careful in the hearing to focus on Daybell's rights as opposed to Vallow's rights. As Vallow concedes elsewhere in her brief, the state steered the direction of the hearing, which occurred on August 30th and was continued to September 8th, 2021, to focus on Chad's rights to conflict-free counsel rather than Lori's right to counsel of her choice. The district court's order disqualifying Means was entered in Vallow's case, focused solely on Vallow's rights. Vallow's concession with respect to the content of the hearing at least implicitly acknowledges that Daybell also had rights that needed to be protected because of Means' conflict. Unsurprisingly, the arguments over Daybell's rights happened in Daybell's case, and the arguments over Vallow's rights happened in Vallow's case in writing. In a footnote, it says Vallow has not raised on appeal the argument that the district court should have held a hearing in the Vallow case. In any event, the district court did not need to hold a hearing because Means never objected to the state's motion. And it says, see U.S. versus Mays. Affirming disqualification of defense counsel, even though district court did not hold a hearing because, although defense counsel said he would file a brief in opposition to the motion, he never did. Means had the opportunity to participate in arguments over Vallow's rights by filing a response to the state's motion in the appropriate forum. He just chose not to do so. Vallow has thus failed to prove her constitutional right to counsel was violated. So we're going to end it there. They keep going about this for a little while, and we are on page 30 of 68, so still a ways to go. And that is it for today. I hope you guys have a good rest of your evening. See you soon.